the name to you, where the question of consumerism came, and first time it has been argued in court of law in respect to the service provided by the doctor to prove that are they come under Consumer Protection Act. And finally, court has decided that doctor is also providing us services, and definition of Consumer Protection Act when they read the services has said it includes everything, because definition said including but not limited. And then few examples were given where medical word was not there. Full definitions are read together, find that every services comes under Consumer Protection Act, and finally the judgment was given and medical practice was brought under the consumerism, and thereafter we are seeing the result. CPA Act 2019 also says the same, and we are governed by this law. Followed by another landmark judgment delivered in respect to the criminal liability in 2005, where a patient was admitted, terminal cancer patient was needing oxygen, 84-year-old patient was on oxygen. Suddenly oxygen cylinder got emptied. Doctor got a call. He rushed. Immediately he brought the oxygen cylinder from next room. It has taken a minute to open the knob of the cylinder because it was very tight. In that bargain of 3, 4, 5 minutes, patient could not able to get oxygen, patient died water oxygen. Court has heard this matter because doctor was booked under criminal liability. Doctor was booked under 304A. Doctor went to Honorable Supreme Court to discharge it, and first time ever interpretation of criminal law was done under this judgment. This is one of the beautiful judgment of Jacob Matthew, where court has narrated everything in this judgment. This is one of the beautiful judgment. You must read it. In this judgment, court has said with the fearful mind, with a trembling hand, doctor cannot do a surgery or give a good medicine to the patient. The fear of law need to be taken out from the mind of this professional. Hence, they said, while delivering the judgment, that medical science is a complex science and human body is a complex machine. Hence, for every medical mishap in the form of death, doctor must not be held responsible. So beautifully narrated. If due care has been given. And court has gone a step ahead, saying that since police authorities, advocates, and other people are not an expert in medical science, being exact science, if at all any criminal cases need to be registered against the doctor, it must be referred to the expert body for their opinion. An expert body must have one doctor specialized in a particular field, preferably from the government hospital. That's the reason while filing a criminal case against doctor, it becomes mandate on a police authority to take an opinion from the expert body prior to arrest a doctor or prior to book a doctor in particular. So spot arrest is not possible in respect to medical practice where death has happened on table also. So one of the beautiful judgment, and the same judgment, my friend, first time occupational medical negligence and professional medical negligence has been well interpreted by the law body, by 3 benches judges, Honorable Supreme Court. They said section 304A, which says causing a death without intention with negligent act, up to 2 years punishment, applies to the driver also. While driving the car, if at all some passerby comes, he dies, then also he is booked under the same section. And when patient dies on table, The same section has been put on doctor also. And then court has observed that both have got a different occupation and different risk in their life. And court thought, why not define this in a proper manner, and beautifully narrated judgment which clearly says that to fasten a criminal liability against the professional, negligence must be gross. The word used, gross or high degree of negligence. So all simple medical negligence, if you see in a medical practice where patient dies, 90% cases, it is just simple negligence, not a gross. Gross means which can be seen from the eyes. Instead of left, right cataract is done. Instead of left, right amputation done. Or mop left inside, leading to septicemia and death. These are comes under the gross. Very rare chances of gross or high degree. And that's the reason why you will find criminal medical engineering cases very less against the doctor. Simple negligence, yes. Court says you can go to consumer fora any simple